Welcome to the webinar, Managing Client Trust Accounts and Ensuring Compliance. During this session, our speakers are going to discuss the responsibilities that attorneys bear in relation to client trust accounts, especially in light of recent bank failures within the financial sector. Additionally, our speakers will provide comprehensive insights on state bar regulations governing trust account practices. And now for a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually and, unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. At this time, it is my privilege to introduce Paul Garibian, Jordan Turk, and Jonathan Grab. Paul Garibian holds an MBA from the Wharton School of Business and is a fintech entrepreneur and executive that has spent nearly 20 years building innovative financial service platforms. Paul is co-founder and CEO of Noda, a legal industry fintech that adds value through personalization, increased productivity, and decreased compliance risk. Noda is built primarily for small law firms and solo attorneys and aims to help simplify and personalize banking. Jordan Turk is a graduate of University of Arkansas School of Law and is a practicing attorney in Texas and is also the legal technology advisor at Smokeball. Her family law expertise includes appeals, pre- and post-nuptial agreements, as well as complex property division and highly contentious custody cases. In addition, Jordan has given CLEs across the country on topics ranging from client relationships to proper trust account management. Jonathan Grab is a graduate of Florida State University College of Law and is the director of the Ethics and Advertising Department for the Florida Bar. Before becoming the Ethics Counsel in November 2021, Jonathan served the department for 8 years as an Assistant Ethics Counsel. Jonathan has fielded more than 20,000 calls on the ethics hotline, reviewed thousands of lawyer advertisements, and issued dozens of staff opinions. Thank you, Paul, Jordan, and Jonathan, for presenting today. I will now turn it over to you.
Thank you, Jamie. Wonderful to be here. Jonathan, Jordan, it's been a while since we've seen each other, but I'm really hopeful that the content the three of us will share will be very beneficial to the Florida Bar members, because even though the banking events transpired and continue to transpire since March, but we're recording this in September, but it appears to be that they're all very relevant. So again, thank you so much for having us, Jamie. Looking forward to the presentations of my colleagues here and, of course, the discussion at the end. And with that, I have prepared a few slides that I want to share with our audience. And hopefully this is we'll have enough take-home value and, for them. As we've talked about in the introduction, we're recording this CLE in September 2023. There has been a number of events that transpired earlier this year that created lots of anxiety and lots of questions around responsibilities of attorneys as fiduciaries for the IOLA accounts, as they're called in the state of Florida. And so myself and my esteemed colleagues on the panel, are planning to talk about some of those events and what to do, most importantly, actionable steps one can take to protect the public and the funds that they are responsible for. And so with that said, trust accounts in banking today, I believe that there are three questions that most attorneys ask themselves in light of recent events. And so from a responsibility of selecting a depository institution and a bank, what liabilities and what responsibility as a fiduciary one has. And at the end of the day, it's all about doing the right thing. That's how I think about it. And while there is no existing cases around malpractice exposure that at least myself and my team are familiar with, it is probably best to use best judgment to select an institution that is stable. And there's ways to kind of look at different reports for banking institutions to make sure that that institution is stable. But ultimately, it just comes down to really the simplicity of the FDIC insurance. So the first thing I would look at is really make sure that that particular bank has FDIC insurance. And most, if not all banks do. And look at the FDIC limits for that institution, because for an individual attorney, and even for most of us that are in the banking industry, it is very difficult to determine whether that particular institution is stable or not. So I would simply make sure that the $250,000 limit per person on the account is in place, and those accounts are properly set up. And then if you have the ability to do a little research around the stability of that financial institution before opening those accounts, that would be the first step where I would start. Identifying that institution is very important, right? One, I would also look at, do they have IOTA experience? Because there is, especially in larger banks, there is many employees, and IOTA accounts are not as common as small business checking accounts. And sometimes if a bank does not have the experience, or the person in that particular bank doesn't have the experience handling those IOTA funds, they can be set up incorrectly, or sometimes we've seen that even they end up opening a trust account or an escrow account instead of the IOTA account, and it's just simply because they're not super common, and with thousands of employees, that just unintentionally happens when the wrong account gets opened. So when you work with a financial institution, with a bank that specializes with working with solo small firms, mid-sized firms that use those accounts, that would be probably the first step or first set of questions to ask. The second step is to look at those FDIC thresholds. The FDIC threshold is $250,000 per person across all accounts, and that includes IOTA accounts, business accounts, personal accounts, and so if you go over that limit, I would look to add additional accounts to that way, to spread the risk across multiple financial institutions to make sure that you get the FDIC coverage. As we've seen earlier this year, the Fed stepped in and basically bailed SVB and First Republic Bank, which ended up getting acquired by JP Morgan Chase. So so everyone else, all the funds were secured, and everything ended up working out. But in the event that doesn't happen, it's probably wise to make sure to stay below the FDIC limits. And so, for example, if there's one partner in a firm, that's 250. If there's 2 or 3 beneficiaries, then obviously those thresholds go up. So if you have 3 partners, that can go up to $750,000 to be covered with the FDIC insurance. But if you're going over, you've got bigger funds, I would recommend opening additional IOTA accounts, but following the same selection criteria, making sure that they have the experience, that bank has the experience setting up those particular accounts. And if you follow those 3 steps, in a unlikely event that there's going to be more bank failures, this year or next year or whenever else in the future, at least now you have the foundational infrastructure in place, not to worry about things that are fundamentally outside of your control. And so very simple 3 steps, highly recommend you follow that. The next step is we find that over 50% of attorneys today don't have the right infrastructure, in addition to having the right bank accounts, the right IOTA accounts, the right tools to support them to manage the trust accounting process. And it can be a big burden, in addition to running a business, in addition to practicing law and taking care of your clients. It requires to also deal with, as a fiduciary of those funds, to deal with certain trust accounting standards required by the state bar, in this case, the Florida bar. And vast majority of questions that the bar gets or attorneys, come up with are around like, how can I make sure that I am managing those funds properly? And some of the cases you hear in the news where people mismanaged funds or did something evil, it's very rare. Most of the time, people get in trouble and get audited because they just simply did not know the rules. We find people that sometimes attorneys that don't even realize that they need to open an IOTA account, and they run a lot of their cases through the business checking account, which is, clearly is a problem. So that would be commingling of funds, right? That's the most common unintentional yet avoidable violation of commingling funds of your clients with your business checking account, or even sometimes your consumer checking account, your personal funds. And so it's best as soon as you hang your shingle, you start your practice. If that's not in place and you somehow we're doing that, just basically have 3 accounts set up. It's your IOTA account, your business checking account, and of course your personal account, and be able to separate the funds, make all the funds separate, have the right tools that help you track those funds very separately, have the ability to make the money movements, and most importantly, not move unrelated funds from one account to the next. And another common avoidable mistake that we see is negative matters. So it's very easy to go over certain client balances and charge it to another client. So it's very important where you have the guardrails and the tools to be able to keep track of those, and have the sub-account functionality in your trust accounting software to be able to distinguish the funds from client A to client B. And at the end of the day, be able to run monthly 3-way account reconciliation that keeps you in compliance and avoids any issues down the line. And that process is easier said than done. If you're doing that process manually and you don't have trust accounting software that is designed to be able to do that. There are some general accounting tools that have the functionality for IOTA accounts, but we find that a lot of them have features like cost of goods sold and other general accounting functionality that makes it very difficult for attorneys to navigate, but they're more designed for CPAs and not attorneys. And IOTA accounts must be managed by the attorney and no one else, because there's fiduciary responsibility. So if you're handing over those funds to your CPA or a bookkeeper, that is also very problematic and can get you in trouble. Record keeping and client fund tracking, that also needs to be very simple, because if that's not in place, and that, if it's a manual process, we find that it's very painful for someone to be able to do, especially as your caseload is growing and number of clients is growing. And then this becomes a big distraction and, triggers challenges down the line. So this is a quick snapshot of 6 unintentional yet avoidable IOTA violations. Last but not least, there is a layer of protection on a firm side as it relates to trust accounting tools. And some are required by the National Law Review, and those are the 8 boxes on top. But then there are 4 additional boxes at the bottom that we at NOTA have identified by working with various auditors, including the auditors of the Florida Bar, to be able to make sure that we add the additional layer of protection to provide the guardrails and support to make this process straightforward and simplify the compliance process for particularly solo and small firms that usually tend to be very hands-on and manage the trust accounts. I won't get into each one of those particular tools that we've identified. You can probably, read this on your own, and some of my colleagues on this panel might get into it in a little more detail. But this is kind of the overall overview, and I hope that you found this very helpful. That's all I prepared today. Thank you, and I'll hand this over to Jordan.
Thanks, Paul. I'm just going to get my screen pulled up. So hopefully everybody can see that. But I really just want to, and I know that Jonathan is the expert and master on this, so I'm really just going to go into kind of a brief refresher on what an IOLTA account. I know that it's IOTA for Florida. Please excuse me and my Texas, in my Texas leanings, and I'll use those interchangeably. So I apologize for saying IOLTA instead of IOTA. But so I really just want this to be a basic refresher from, your MPRE days or your professional responsibility days. Think back to those wonderful, optimistic times when we were all very happy and excited about practicing law. But we're going to start off with what your IOTA actually is. So everyone knows this is your interest on lawyer trust account, obviously called different things by different states. And as I'm sure Jonathan will note, in Florida, obviously, again, it's an IOTA, but essentially it's an account that you use to store your client's property or to store third-party property, which is a big deal, and we'll talk about it. But it's not your money yet, and you have not earned those funds. So therefore, you have to protect them, right? And you have to hold them in this account. And that's going to be different from your operating account, obviously, where you pull out your payroll. That's how you pay rent, things like that for your office. And every state bar, which of course we're going to go into here in this CLE, has their own rules with regard to these trust accounts and what they can and cannot do with them. And everybody should be very familiar with Rule 1.15, which basically every state bar has in one form or fashion, because we all have to adhere to it. And it's actually one of the biggest offenders when it comes to grievances that are filed against attorneys. And as Paul was talking about too, this is causing a lot of hot water, especially in places like California. When we're talking about three-way trust account reconciliation and how important that is, there's actually, I think, over 2,000 attorneys that just got a not so pleasant, email from the bar about how they're no longer in compliance because they just pushed out their own three-way trust accounting rules, which everyone has to adhere to. It's called CTAP for California. So it was a huge swath. I want to say it was some 2,500 attorneys that were now found to be not in compliance with their state bar due to their inability, or maybe they just did it wrong, to do three-way trust account reconciliation. So something to think about as you go forward, as you're choosing what type of technology to use, or you're trying to figure out how to do, what to do with your trust account reconciliation. Make sure that you do it right the first time. Otherwise, you're going to mess up every subsequent month, and it's going to be an absolute nightmare for you. So just something to think about as you go through. But as far as Rule 1.15 and the sanctions or the malpractice that goes along with that, I would say from what I've seen and talking to a lot of state bars from across the country, probably somewhere in the neighborhood of 70 to 75% of grievances are coming from some sort of issue with your trust account. It might not be even something that you willingly did. It's not something that you maliciously did. As Paul was saying, a lot of times it's just, you just did something wrong, but you weren't actively going in there, taking out a bunch of money from your clients that you haven't earned yet and going to Vegas for a weekend, right? A lot of times it's these little innocuous things and you just didn't realize that you were doing something wrong. But getting back to this, we all know that for some reason, a lot of attorneys get into trouble when it comes to Rule 1.15 or when it comes to their trust account. And that's kind of, we're not going to necessarily get into super big detail about that for this particular CLE. And I know that Jonathan will probably go into more detail about 1.15 and what particularly the State Bar of Florida does or the Florida Bar does. But essentially, what we need to know for the purposes of here and how I'm talking is we need to keep these funds safe, and that we need to keep them, we hold ourselves to a fiduciary standard. Okay, so as Paul was saying too, pretty much every state bar, Florida included, is going to require you to deposit funds with regard to your IOTA account into an FDI insured bank. So what do we mean by this? What does FDIC mean? We see it all the time, but what does it actually, stand for? So the FDIC obviously stands for the Federal Deposit Insurance Corporation. Say that 5 times fast. But essentially what happens is banks pay a premium to the FDIC, and in return, they get this wonderful insurance coverage. So the current limit, as Paul mentioned, is $250,000. So that's your cap, that's your limit. But actually, this didn't used to apply to credit unions. So attorneys used to actually stay away from credit unions with regard to this. But in 2014, a law was passed that said, hey, no, actually, this has to apply to both banks and credit unions. So if you were on the fence about utilizing a credit union for your IOTA account or anything like that, and were wondering if there was coverage, there is, in fact, coverage now for credit unions as of 2014. But for attorneys especially, and what I really want to point out with regard to FDIC insurance coverage, and what Paul had mentioned too, this $250,000 cap is per client. So it's not per your trust account. So as long as your trust account is qualified as a proper fiduciary account, which the vast majority of them are because you are in fact a fiduciary, according to pretty much every state bar in the United States, that's going to be $250,000 per client. So it's not just your trust account. So if you're freaking out and wondering, hey, I have $500,000 total in my trust account, oh my gosh, it's $250,000 more than the limit, remember that it's per client, not per your trust account. There is kind of a possible, but I would say extremely rare issue that I want to point out and that you should maybe look out for is if your client banks at the same financial institution in which you have your IOTA. So there could be a possible issue with that because that $250,000 cap is actually per bank. So if you're looking at, say, depositing $900,000 of your client's money, let's say it's a real estate transaction or something like that, and you're looking at putting that into your Wells Fargo trust account, but then turns out your client also banks there personally and has another $200,000 on deposit, well, that might be problematic for the client and can actually maybe hinder the recovery of those funds if that bank were to fail. So something to keep in mind, and maybe as you go along, especially for family law attorneys, it's pretty easy for us because by the end of the initial client consultation, we get an idea of what the estate looks like for the client. So it's easy for me to say, oh, maybe there's an issue. I might want to ask this client where they bank to make sure it's not at the same bank as my IOTA account. It's just one of those things maybe that you want to start incorporating, especially if you're dealing with a lot of money in your practice. Maybe you have a real estate practice or some transactional practice too. So something to maybe think about as you go forward. I don't foresee it being a huge issue for everyone, but it does exist and it's out there. All right, next slide. I'm not going to get into heavy ethical because I feel like that's Jonathan's area, but just as far as ethical duties and how I view them and what I'm most concerned about, I'm always concerned about ethical issues because I am a very paranoid person just by nature. And I feel like attorneys in general are just very paranoid people. Welcome to the profession. But so for me, I kind of live in this constant state of anxiety, wonder if I'm going to be sued or if there's a grievance that's going to be filed against me, especially in family law. It's just the most fun. But now on top of that, I have to worry about what happens if my bank fails. So it's just another layer of stress. It's just super wonderful for me and all of us out there. And so the questions that you might have would be, okay, one, if I hold more than $250,000 on behalf of my client at my trust, do I have an obligation to minimize that client's risk in the event that that bank fails? Right? Because I'm now over that $250,000 cap. And then also, what's my liability? What does my bar say? Are there any other implications that you know of? Then also, what about client funds that are unrelated to a retainer payment? Like, what if I'm just holding these funds? It's not mine, I promise. What if I'm just holding these funds on behalf of a third party, right? So if it's a real estate transaction or something like that, or say a home was sold in one of the cases that I have and the court wants me to hold those proceeds, but I can't bill against those proceeds, right? So I'm just holding them on behalf of the client. You know, is there any case law or guidance on or ethical obligations in the event that I exceed the threshold of that $250,000, right? Because we're not really worried about if the money in the account stays under that $250,000 cap, because no matter what, the FDIC, you know, the regulators, they're going to step in if that bank fails, and they're going to meet that insurance minimum. So I am not concerned about accounts that have sub 250K in them because they're going to meet that threshold. And so as attorneys, you're really just worried about, at least for me, am I choosing the right bank, which Paul talked about before? And then second, am I depositing more than that $250,000 cap? And do I have an obligation to minimize the risk for my client with that should the bank fail? So that's what I'll talk about in a second. Oh, and then also third, I would think about, is there any standard by which attorneys are scrutinized when it comes to selecting a bank? So just spoiler alert, there is minimal case law on this. A lot of them are older, but there is one actually from 2005 that should be popping up next. All right, so this is the case from 2005. It's a New York case. It's called Bazinet v. Klug. Who knows if I'm pronouncing that correctly? But really quick background is that you have this attorney Reiser, so it's not Bazinet, he'll come in later. But you have attorney Reiser, he acts as an escrow agent for Klug in this case. So it's a real estate transaction. There's actually 2 New York City apartments. They're right by Central Park that Klug wants to buy. Must be nice. I wish I could be one of those people. Well, maybe not Klug, as we will soon find out. But what ends up happening is attorney Reiser goes and, you know, as the escrow agent, he deposits a couple of deposits. So 1.45 million and then 1.28 million as down payments for these apartments from Klug. So he goes in and he goes into the New York branch of the Connecticut Bank of Commerce. That's where Attorney Reiser had his trust account. That's where he liked banking. He understood this bank. He likes this bank. There you go. However, before the transaction concluded, and unbeknownst to all the parties in the case, the Connecticut Bank of Commerce actually closed down and the FDIC was named as a receiver. So super great. Bazinet, that's where he comes in, is pissed because he's one of the buyers in this case. So he sues to actually recover the down payment of his money. Then he also says, you know what, Attorney Reiser, I fully believe that you committed malpractice. Do you know why? Because you deposited those funds and you didn't do it so that they would be under the threshold that the FDIC covers, right? Obviously, the millions of dollars exceeded that $250,000 cap. And then he says, or at a minimum, you didn't take other steps to protect these funds that you knew were in excess of the cap. So Bazinet is pissed, and this results in his cross-claim against Attorney Reiser. So Attorney Reiser ends up filing a motion to dismiss the malpractice claims, and the court actually grants this motion, and they say, look, to prevail in a malpractice action, the plaintiff has to show that the attorney failed to exercise the degree of care, skill, and diligence commonly possessed and exercised by a member of the legal profession. So they said that there had been no allegation that Attorney Reiser violated any state law, any statute, any regulation, and also there is no requirement imposed by law that an attorney escrow agent has to place these escrow funds in an account that's fully insured by the FDIC. So there were no allegations that Reiser knew anything about the bank closing. They essentially said, hey, the proximate cause of Klug's injury, if any, was the bank's unforeseen demise. And so that malpractice claim was dismissed against Attorney Reiser, but that's essentially what this court held, that this was an unforeseen issue. Nobody could have known that this bank was going to fail. So there was no allegation that Reiser had done anything wrong with regard to this bank because he just had no idea. And that's how this case was decided. And there's also a Florida ethics opinion that I'm sure Jonathan will go into in more detail. But essentially what they found there was, oh, yes, hey, attorney, he routinely kept several $100,000 in his trust account over the cap, over the threshold. And this lawyer wanted to know and asked the Florida bar, hey, do I have actually any legal liability since I'm holding this over that cap, over the threshold? And the bar essentially said there's no ethical requirement to divide these trust funds, but you have to act prudently. So prudently being the key word there, the operative word. And so what that means, it's almost like the law school reasonable man situation. We don't really know. There's no codified definition of what prudent actually means. So case law would be instructive here. Ethical opinions in addition to this are instructive, but that's the standard that they promulgated. And then there's also a South Carolina ethics opinion called OA-10, and that's where they said that the attorney is under no obligation to provide insurance over and above the maximum available by the FDIC, and that the lawyer only has the obligation to take reasonable steps to protect the client's funds. So to recap, we have unforeseen circumstances that was noted in the Bazinet case. You have to act prudently with regard to the Florida bar. For South Carolina, it says you have to take reasonable steps. Connecticut also has an interesting opinion. So their bar opinion 91-02, this was put out in 1991. Think back. And this was where the attorney had a question about whether they had any ethical obligations or responsibilities if a client's funds exceeded that threshold set by the FDIC. And the short answer that the Connecticut bar said was no. However, Connecticut went into really great detail about this, and they said, hey, like most jurisdictions, we require that fiduciaries act as a prudent person. So obviously, it sounds very familiar to Florida, right? And so they said you have to act as a prudent person would have acted in handling trust properties and funds. But what does that actually mean? Because we don't actually know, right? But it does go deeper in that opinion, and it said in the commentary in one of their ethical rules that you are held to, quote, a professional fiduciary standard as an attorney, which implies that you have some special skill or more facilities greater than the prudent person, which you must use in managing client funds. So it even goes a step above and says, not only do you have to act prudently, but now you also must hold this professional fiduciary standard. So what that actually means, though, again, not really laid out in any type of concrete fashion, but they go on to say that we assume that the prudent person would, one, take advantage of FDIC insurance coverage when it is practical to do so, which makes sense, right? You're not just going to some random fly-by-night bank that's not FDIC insured. So they're basically saying we understand that they exceeded the limits, in this particular matter and what this attorney was asking, but that attorney used an FDIC insured bank and it was practical for the attorney to be able to do so. So they said that there was no ethical implication whatsoever or issue with the attorney doing that. In another case that Connecticut cited in their opinion, very interesting. I know you were all just loving this case law talk, but it's US v. Howard. It's actually a case from the 1930s, which is interesting because you have Great Depression era going on. So obviously a lot of banks were failing at this point too. And I think clearly you're a professional fiduciary. And so in an age of bank failures, as they had in the 1930s, and we're kind of having a little bit now, you have to exercise a due care standard, and you need to be careful in selecting banks with which you deposit your funds, as Paul mentioned before. So in US v. Howard, the court held that it was actually a jury question, very interesting, and I'll get back to that, on whether a bankruptcy trustee had breached his duty of care. So what he did was he went and deposited a number of trustee bank accounts in excess of the surety bond. So think like precursor to FDIC. So he deposits all of these accounts. They're in excess of the bond that was posted by the bank. It was all done above board, right? It was done pursuant to the banking laws at the time. However, the trustee knew of several runs on that bank, and the bank subsequently failed. So the issue here is not so much of an unforeseen circumstances, right, that they talked about in the Bazinet case. Instead, here it's about he knew that there were several runs on that bank in the past, and yet he still deposited accounts into it. So for those unfamiliar with what a run is, what a bank run is, it's when everybody goes all at once and they try to withdraw all their money from the bank at the exact same time, essentially. So Howard had known about the runs on this bank, yet he still deposited this money. So the Supreme Court actually said, we're not going to dismiss this case. Actually, we're going to send it back down to the lower court because it's a jury question, but they did not outright dismiss it. So something to keep in mind as you go forward and you're asking yourself, okay, there's not really any codified standards. There's no statutes. There's no laws. However, there are a lot of ethics opinions, or at least a good amount, when you take it from all of the states. And case law does exist saying, hey, it's fuzzy, but there is some standard by which you need to adhere. And a lot of it is reasonable, prudent, and professional fiduciary standards. That's my spiel on the case law here, and I will pass it over to Jonathan.
All right. Thank you so much, Jordan. And thank you, Jamie and Paul, for your introductions and great work. So, as previously noted, I am Jonathan Grab. I am the director of the Florida Bar's Ethics and Advertising Department, also known as the Ethics Council for the Florida Bar. And basically, if you have any questions, of course, we do have the ethics hotline for Florida Bar members. And please, if you ever have a question regarding trust accounting or any other ethical issues, including lawyer advertising, feel free to give us a call at 1-800-235-8619. And yeah, those questions, of course, we can only help you with your own proposed future conduct. We can't give an opinion about somebody else's conduct. That's up to lawyer regulation. But yeah, save yourself some time, if it will, and give us a ring. So to start with, I'm going to go through and explain some of the distinctions between the Florida Bar's rules and the ABA model rules for trust accounting, as well as just give some fun sort of foundational knowledge regarding trust accounting issues. So first, ABA model rule 1.15 is the safekeeping property rule in the model rules, and it consists solely of 5 headings and approximately 2.5 pages when you count all of the rules and commentary. Now, the Florida Bar, our rules have Chapter 4, which is the entirety of the rules of professional conduct, and we do have 4-1.15, but really what it says is it just incorporates everything that the Florida Bar has in Chapter 5, which is what we refer to as our trust accounting rules. And our trust accounting rules go into much greater detail than what you'll see in 4-1.15 or even Model Rule 1.15. And instead of just 5 headings and about 2.5 pages, our rules and commentary altogether are about 20 headings and nearly 20 pages of rules and commentary. So there's a much greater degree of detail that you're going to see in the Florida Bar's rules than you would get in the ABA model rules. And that's important in part because, yes, we all trained in law school on the model rules is generally what we're taught, not necessarily the Florida Bar's rules. So make sure that when you're operating a trust account in Florida, you are looking to Florida's rules. So what is a trust account? Of course, it's an account where you hold, as a lawyer, the property of clients or third persons that are in your possession in connection with a representation. And so that could be an IOTA, an interest on trust account. where the interest accrues to the Florida Bar Foundation, and where those funds are short-term or nominal in value. And essentially, that's sort of that aggregate account where you hold most of your client's funds. But on the other hand, you may have some instances where you have a client whose funds are short-term or nominal. And in fact, you should have those in an individual trust account for the benefit of that specific client. Say that they, now that interest rates are going back up, that they might get the benefit of that interest rather than it accruing to the Florida Bar Foundation. And of course, when you make that decision, you're going to look at, what is the liquidity that my client needs for these funds? What is the type of interest rate they could actually get versus the bank charges that are going to come along with that? So all of those things are going to go into consideration, but the rule does acknowledge that this is really up to the good faith, sound judgment of the attorney in making that decision. Now, of course, as opposed to a trust account, the operating or business account is the account that holds the funds belonging solely to the lawyer or law firm. A lawyer may have an interest in funds that are held in the trust account, but if anyone else other than the lawyer or law firm has an interest in those funds, they must be in the trust account rather than the operating or business account. So some of the similarities between the rules regulating the Florida Bar and Model Rule 1.15. Yes, again, you have to maintain a trust account for any time that you are holding funds or property belonging to clients or third persons. And those have to be kept separate and apart from your own property. Those accounts may be in an account or should be in an account where the lawyer's office is situated unless the client consents otherwise. And further, a lawyer must notify under both provisions clients and third persons when receiving property in which they have an interest, and promptly deliver to the client or third person any funds that they're entitled to. And finally, if insisted by a client or a third person, you have to promptly render a full accounting upon their demand for any property that they have an interest in. Of course, that's only going to be what they personally have an interest in. But yes, if they have an interest in those funds or property, you have to provide that accounting upon their demand. Finally, one other commonality is that if ownership of the funds or property is disputed, then that property or funds has to remain in trust until that dispute is resolved. And so you can't just say, I'm throwing up my hands, I'm going to give this to my client and let my client sort it out with this other party that is claiming they have the entitlement to these funds. Now, here's some differences between the two sets of rules, the rules regulating the Florida Bar and Model Rule 1.15. So ABA Model Rule 1.15, there is no specific account type required, versus in Florida, it specifically provides that the funds must be in a federally insured bank, savings and loan, or credit union. Further, technically the model rule, now I'm sure plenty of other states refer to IOLTA or IOTA or IOLA programs, but the model rules technically do not have a reference to those programs, while the Florida Bar rules, again, a significant portion of our rules are actually dedicated to the operation of those IOTA accounts and the IOTA program for any funds that are short-term and nominal. Further, the ABA model rules note that you have to abide by generally accepted accounting practice and record-keeping rules established by law or court order, whereas the Florida Bar, those are very explicitly written out in detail in Rule 5-1.2 in particular, as far as those record-keeping requirements. Any reporting, such as your trust account certificate to the Florida Bar, any notification regarding if you have an instance where you're using your own funds to correct a shortfall that might have occurred in your account, anything like that. All of that's addressed in Florida's trust account rules in great detail. Further, the ABA model rules talk about a 5-year retention time period following the conclusion of the representation, where the Florida Bar requires 6 years for retention of those records. And there's no specific bank notification process. Again, because they don't really have a reference to IOTA programs in the model rules, they don't have that specific notification, whereas the Florida Bar does, including a notice letter to the bank, where essentially the bank is supposed to tell on you if you do something wrong with your trust account, and you're directing them to do so via that letter, and notice to the Florida Bar Foundation that you are opening an IOTA so that they know that they should be receiving the interest on that account. Further, there is no account naming protocols specifically stated in the model rule, whereas Florida's rules explicitly state that your trust account must include the name of the lawyer or law firm and the words trust account. IOTA is not sufficient. The abbreviation on its own is not sufficient. You have to specifically have the words trust account in the name of the account. So again, the IOTA program. This is addressed in Florida's Rule 5-1.1 subsection G. And of course, this is available on the Florida Bar's website if you want to look up the rules. But it's interest on trust accounting. And that interest, again, accrues to the Florida Bar Foundation. To be clear, the Florida Bar, the organization I work for, is not getting rich off of your interest. This is going to the Florida Bar Foundation, which then uses those funds, that interest that accrues, to provide legal services, pro bono services to those in need. Further, it requires in the rule that it must be, quote, the highest interest rate or dividend generally available. So yes, it actually has to be an interest rate that is matching the highest generally available to consumers who would have those types of accounts or similar accounts. The aggregated accounts for funds in an IOTA, again, are going to be only for those that are short-term and nominal, but it's going to be presumably numerous clients if you're holding funds and property for numerous clients. And so, yes, you have to track that information, of course, in the relevant ledgers and balances. And then there's a list, again, of considerations in 5-1.1 sub G3 specifically in making that determination of whether or not the funds are short-term or nominal in value. And again, that's going to go into things like the liquidity, just the general expectation of how long the funds will be held, all of that. And again, the specific quote from the rule is that no lawyer will be charged with ethical impropriety or other breach of professional conduct based on the exercise of the lawyer's good faith judgment. We are not expecting you to be the perfect investor who always is going to maximize every possible cent that could be going into that program or that could be in the alternative going to your clients if they had their own trust account. Rather, again, you just try and make a good faith judgment about whether the funds are going to be short-term or nominal. So again, further requirements for an IOTA account in Florida, it has to be what's known as an eligible institution, and it has to be an interest or dividend-bearing trust account. Eligible institution is actually defined in the rule, and basically that's an FDIC-backed bank or savings and loan authorized to do business in Florida, or an insured credit union authorized to do business in Florida that is backed by basically the FDIC equivalent for credit unions. Interest, or as far as an interest or dividend-bearing trust account, what that means, again, that's defined in the rule. And there's this weird sort of little niche about that can include a daily financial institution repurchase agreement that is fully collateralized by U.S. government securities, or a money market fund consisting solely of U.S. government securities. But that being said, and I'll get into an explanation of what that means in just a moment here, those funds must be subject to withdrawal on request and without delay. So if you had a daily financial institution repurchase agreement or a money market fund, but the funds were not subject to withdrawal on request and without delay, then it's still going to be a potential problem for your IOTA. In Florida, another note is that we have a rule addressing uncollected funds, that you cannot disperse funds before they have been fully collected by your trust account, and except under very limited circumstances. And that's going to include things like they're coming from the Florida government or U.S. government, they're coming from an insurance company under very specific circumstances, or another lawyer's trust account. But if it's not one of those criteria explicitly stated in Rule 5-1.1 sub J, then you have to hold on to those funds and cannot give them to anyone, including your client, until they have actually been collected. And to be clear, sorry to be redundant, to be clear, that does not mean cleared. Because a lot of times your bank or your institution will tell you that these funds have cleared. That does not mean that they are actually collected and in the possession of the bank at that point. And instead, they must be, quote, deposited, finally settled, and credited to the lawyer's trust account. So again, some of those exceptions are going to be certified checks or cashier's checks, loan proceeds from a banking or institutional lender, bank checks, official checks, money orders, and credit union checks if you have a reasonable and prudent belief that the instrument will clear and be collected within a reasonable amount of time. Federal or state government checks, again, checks from another lawyer's trust account or a licensed real estate broker's trust account if, again, you have that reasonable and prudent belief that it will be collected within a reasonable amount of time. And then finally, again, checks issued by Florida licensed insurance companies. Now, one thing I would note about this is that when you're talking about those bank checks and money orders, we've actually had some issues where there have been some very sophisticated scams. And those scams may have bank checks that look like they're coming from a valid institution, say in Canada, and that they are an actual cashier's check. And when lawyers try and go and deposit those, they have sometimes been a fraud. And certainly that's something you want to be very careful about. And that's where you really want to look at that language that says you must have that reasonable and prudent belief that they will be clear and collected. If it seems too good to be true, and say somebody calls you or emails you to represent them in a collections matter, and the moment you send out that demand letter to the debtor, they suddenly say, "Oh, absolutely, I'll send you the check," and you get a check from some random institution in Canada or wherever else, and it seems a little odd that they were so eager to pay once you just sent them a letter. Yeah, it might be too good to be true. Give that check a little bit of time and make sure it's collected before you disperse against it. So to get back to sort of the original topic here, and that is FDIC coverage. And Jordan mentioned this briefly in her discussion, and that is really our primary source here is Florida Ethics Opinion 72-37. And the summary to that opinion notes, quote, "Although there is no ethical requirement that a lawyer divide trust funds in order to ensure complete FDIC coverage, he is nevertheless," and I apologize for the gender terminology, it's 50 years ago, "he is nevertheless expected to act prudently and consider the deposit's size in relation to the size and reputation of the financial institutions concerned," end quote. And so, again, that's really getting back to that notion that you are not absolutely required in all circumstances to ensure full FDIC coverage. And ideally, it's a fairly rare instance that a bank is going to fail. But yes, it does happen, which is why the FDIC exists and why that coverage is there. And yes, again, as Jordan noted, there are going to be situations where if you have information to suggest that this is not a stable institution with where there have been previous runs on that bank, then yeah, you may want to reconsider using that institution, of course, and you have to act in the best interest of your clients. So in the context of this opinion, again, it was from 1972. At that time, FDIC coverage was limited to $20,000. Current FDIC coverage, as noted by Paul, is $250,000. And as they also both discussed, that applies to each owner with funds in the fiduciary account. It's not per account, but as they noted, also, again, that could be an issue if you have that person also using that institution for their own banking, where, yes, the funds you're holding for them in that institution may run over that cap when combined with their own personal funds. Now, of course, again, you have to have records, those ledgers, for each individual owner as well. So this is something that, again, Jordan already went through a bit, but we don't have any disciplinary cases on this. Rather, there is that Bazinet v. Klug case, and there's the citation there if you'd like to look it up, for malpractice. And yeah, again, the court did not find that there was malpractice for lacking full FDIC coverage for those funds when there was no allegation that the lawyer knew that the bank was in danger of closing. And frankly, we're lawyers. We're not usually financial professionals. We don't have time to do all of that research in many instances. But, yeah, you have to be reasonably informed. Now, frankly, yes, if you're seeing something in the news about the institution, that's one thing. But for the most part, yeah, we have to rely on those individuals and regulators who are more knowledgeable about this stuff. And if they don't see it coming, the Florida bar is not really going to expect you to see it coming either. All right, so to get back to those daily repurchase agreements, these are sometimes referred to as sweep accounts. It's a certain type of sweep account if you want to look up the term or if you're familiar with it. And those are permitted in Florida for Florida IOTA accounts only if it, again, is that daily financial institution repurchase agreement that is fully collateralized by U.S. government securities or a money market fund consisting solely of U.S. government securities. And part of what these programs have been advertising as of late is that they have what they claim is better FDIC coverage. That essentially what these accounts would do is take your funds in the trust account and disperse them out over multiple banking institutions, again, overnight, so to speak. And then each morning they would have that repurchase agreement where those funds come back into the IOTA account. And therefore, if one of the banks failed overnight, then it would just be that one bank, and presumably all the clients in that account would get that full FDIC coverage. Now, this is a little bit tricky. And honestly, I don't know that we've really seen much testing of this yet, because you're still going to have to comply with all other record keeping requirements if you have a sweep account like this, which might become unwieldy. And I really don't know how effectively the banks, I personally am not familiar with how effectively the banks are able to track exactly how much of each client's funds you have in your IOTA account and then are dispersed out against all these other institutions for when you have more than that $250,000 per client matter. Further, again, the funds have to be subject to withdrawal on request and without delay. And so if in any way that would restrict that ability for you to have those funds on request and without delay, then yeah, you're probably just as well having either the funds in a single account, or if it's significantly over that FDIC coverage, then yeah, just literally have multiple accounts, multiple trust accounts with other institutions to better manage that money. And again, normally these sweep accounts in the past have been used to maximize or increase potential interest on the account. So it's a little bit new that they're being used for this FDIC coverage. And so that's why I say, please, if you're going to use one of these accounts, proceed with caution. And that kind of gets into the last conclusions here that I have. First, again, Florida's rules are distinct from the ABA model rules. So make sure that if you're in Florida as a Florida lawyer, that you are complying with our rules. You're not just looking to the ABA standards. Further, Florida does not require that full FDIC coverage, but you need to act prudently still. And that is an ethical obligation. That could get you in trouble with your license if you fail to do that. Next, I would say document everything. Again, if you're setting up an account with a bank, make sure that you ask those questions and insist on those answers in writing whenever they're available, so that way you can protect yourself as a lawyer and you can show, look, I based my information and my decisions on what the bank provided me, and that's how that's what I've been using to act on. And so again, that goes to, if your bank is not able to give you details about how that sweep account operates and how it really is providing that additional FDIC coverage, or how you would determine which clients' funds are going to be, which institutions potentially they would need to make an FDIC claim from when those funds are dispersed overnight and then recollected in the morning, that's going to be something that you need to make sure you have so that, say one of those banks does fail, that then you can appropriately collect the funds on their behalf. So I think that covers everything I have for my presentation. And I think we might have just some questions for the panel possibly here. But beyond that, I just want to say thank you again for having us speak. And I hope that this presentation is helpful to those who tune in.
Thank you so much, Paul, Jordan, and Jonathan. So I do have a few questions, and I'd love to get all of your feedback on this. How can lawyers exercise due diligence in choosing a bank, and when should they use multiple banks, or is that even something they should consider?
I'm happy to take that, Jamie. I think we, covered it as part of the questions. It's very difficult to assess the viability of the bank. I agree with Jonathan. Do some research in advance, but the simplest thing to do is just open multiple bank accounts if you're over those thresholds. That would be my recommendation.
And Jonathan, you had mentioned that with the FDIC coverage, you're not always obligated to ensure funds are covered. Could you explain that a little bit further?
Sure. So again, and this was partly covered and discussed by Jordan as well. So if she has anything to chime in, I'm I would love to have it. But that is, in Florida, really what you're looking at is that we have an ethics opinion. And yes, our opinions are non-binding and advisory only technically, but it basically says that you are not required to have that full FDIC coverage as a matter of the ethics rules. And we just don't have a lot of times the information, as Paul also acknowledged, to know whether an institution is stable or not. I mean, and it's just not going to be publicly available. If we had that perfect knowledge, I mean, frankly, I'm guessing the government would be pretty interested in talking to us to figure out how we have figured that out better than they have. And so, again, that's really what you're looking at, is that we're not expecting lawyers to be perfect investors or to absolutely guarantee that full FDIC coverage. But if it's possible in the circumstances, it's not going to tangle up a transaction where you're holding significantly more than that $250,000, then yeah, go about getting multiple accounts in the interest of that client to protect their funds.
I like that. Jordan?
Yeah, and actually, I'll just piggyback off of that too, from what Jonathan was saying, because to me, it's not the attorney's job to be a bank monitor, right? So in addition to the FDIC, there's numerous other federal agencies and regulators that monitor these financial institutions and these banks for the purposes of guarding against bank failures, right? So it's not my job to be monitoring necessarily. So I want to presume and hope that these federal agencies are actually doing their jobs and they're making reasonable efforts to safeguard these banks from failing. That's their job. They're better at it than I am, hopefully, because I am a mere attorney. But for me, I think due diligence would be maybe not using a fly-by-night bank, making sure that they are FDIC insured in the event of Silicon Valley Bank. Maybe if I was thinking going to a bank like that and it had just failed, Google would maybe be my friend. And maybe I'd want to just search that name just to make sure, because the first thing that would have popped up if they failed on a Friday and the FDIC stepped in, then if I Googled on Saturday, I think I would learn some very interesting things about it. So to me, maybe Google things like that. But again, as Jonathan said, I don't think the bars are kind of out to get us, and they understand that this isn't necessarily our job. We just have to be prudent to the extent that we can be, right, when we're looking at what banks to use.
Excellent. Yeah, Jordan, you actually were pulling into my next question, because I did want to ask, what would constitute a failure to meet your duties in light of, the recent bank failures? I know attorneys, might be very concerned about that. So if they do put their money into a licensed bank, but it turns out to be a weak bank, what should they consider?
Well, a lot of it is, if you're putting in a huge amount of money that's over the cap, start thinking about why you're doing that. Start thinking about maybe how you want to diversify the amount of banks that you're using, and making sure that each bank that you use is FDIC insured.
Yeah, excellent. Well, thank you so much again to all of you. I really appreciate your time today. And this was excellent information. And I feel like this will benefit so many that watch our webinar. So thank you again.
Thank you.
Thank you so
Thanks
much
for having us.